morning. This is the Board of Appeals, Town of Hempstead, June 14th, 2023, 9:30 meeting. Will everybody please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America, and to the republic. Mr. Chairman, do you have any opening remarks?
Good morning. For those of you who have not been here before, I'll make you aware of the protocol that we follow. Ordinarily, we call adjournments first, and then we'll go on to the calendar. And if there are any requests for adjournment, we'll hear those first. The procedures we follow during the hearings: the applicant comes in, makes their case. If there are any objections, the objectants have the opportunity to present their case, and then we call the applicant or their representative to sum up. These hearings are live streamed, so you can watch them as many times as you'd like. We do have a court reporter. Everything is taken down and archived, and I guess that's it. Patrick?
Mr. Chairman, we have 3 applications for adjournment for this morning. It's cases 30723 near East Rockaway, MSJ Homes LLC, also known as 9 James Street, 30823 near East Rockaway, PST Fine Homes LLC, also formerly known as 14 James Street, as well as 30923 near East Rockaway, MSJ Homes LLC, formerly known as 10 8th Avenue.
Is anyone here on that case? Does someone want to swear him in?
He doesn't need to be sworn in.
Oh,
Not for adjournments.
3. Yeah. Good morning.
Good morning.
Your name and address for the record, sir.
My name is Sovinder Lamba.
Hold on.
Sovinder Lamba. 43 Salem Road, Hicksville, New York.
And you were here requesting an adjournment on these 3 cases?
Yes,
Is
sir.
that correct?
Yes, sir.
The reason for the adjournment?
Last hearing, you asked us to get a real estate expert, so we couldn't find one on time, so we finally found one yesterday. So
Okay.
he needs time, about 2-3 weeks to prepare for the hearing.
So on 5/17, we took partial testimony, and you've been looking for a real estate expert. Have you found one?
He
Yes,
said he
we
did.
yesterday eventually we found one.
Just yesterday?
Yes.
And how much time
Uh,
do
he,
you
he, he,
need for
requ-
this real estate expert to do his or her
He-
evaluation and be prepared to testify?
he requested 2 to 3 weeks.
Patrick? First available?
Mr. Chairman, the first available I have that we don't already have filled up with adjournments is July 26th at 9:30.
Okay.
When you were here last, pardon me for not recalling independently, were there other folks here who wanted to speak on the case?
Yes, ma'am.
Okay.
People in opposition?
No, nobody.
No
Oh,
one
no one in
opposition.
Nobody. I'm sorry, I can't hear you. Yeah.
That's okay. It
That's
happens to me a
okay,
lot.
we're even. We can't hear you that well either.
Okay, then,
Okay, July 26, 9:30.
July 26th? All right. Thank you.
You're welcome.
you won't get further notice, okay?
Sorry?
You will not get further notice.
Okay, July 26th.
In other words, put it in your calendar now.
Will do.
Yeah.
I will do. Thank you so much.
Good. Have a nice day. Any other applications for adjournment, Patrick?
No, sir.
Okay,
Okay. We have case 38123 Inwood. Francia Benavides and Nicole Benavides Carlson Renewal of grant to maintain two-family dwelling converted from a non-conforming one-family dwelling, also known as 63 Roger Avenue.
Okay. Morning.
Good morning.
Name and address?
I'm sorry. Yes. Francia Benavides, 160 Donahue Avenue in Inwood, New York.
Okay. So this is a renewal of a grant to maintain a two-family dwelling converted from non-conforming one-family dwelling. The building department inspected the premises on February 14th, 2027, and they affirmed that all the previous conditions imposed by this board have been complied with. Do you have anything else you'd like to add?
No, sir.
May I ask you, Ms. Benavides?
Yes.
I note that you don't live at the premises. You're one of at least two owners. How is Nicole related to you? Is that a daughter or?
She's my daughter.
Okay, and does Nicole live at the residence?
Yes, she does.
Okay, so I'm sure you're aware, and it sounds like you're in compliance now, but one of you, if you're the only two owners, always has to reside at the premises, okay? And it sounds like that's happening now.
Yes.
Okay, so for future. Okay.
Do I have any other questions from the board?
Move the hearing be closed, the matter be placed on the decision calendar. Ms. Benavides, you will be notified by mail of the board's decision once it's rendered. Okay, thank you, have a nice
Thank
day.
you for coming.
Thank you.
All in favor?
Aye.
Any opposed, any abstentions? Next case,
Next, we have case 38223 Atlantic Beach, 139 Bayside Drive LLC. Renewal of grant to maintain 6-foot-high masonry and wood fence larger than pool installation area, also known as 139 Bayside Drive. Please swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Please take a seat and state your name and address for the record.
Kenneth Long, architect, 870 Gina Court, North Belmore, New York, 11710.
morning.
Good morning.
As you heard, this is also a renewal.
Yes,
Building Department inspected the premises on March 27th of 2023 and found that your client was in compliance with all previous conditions imposed by the board. Do you have anything else you'd like to add?
we just request if possible, because of the nature of this type of fence, being that it's a permanent stone and stucco wall that's very well maintained, if we can either extend or eliminate the temporary conditions associated with it. It is made out of masonry, it's pile supported, so it's a pretty kind of permanent structure, if you will. So that's the only potential consideration, but other than that,
Okay,
that's all.
we'll consider that.
Okay.
All right? Do I have any questions from the board?
Mr. Chairman, I move that the hearing be closed, that the matter be placed on the decision calendar. Mr. Long, you'll be notified by mail of the board's decision once it's rendered.
Thank
you, have a nice day.
Have a nice day.
All in favor?
Aye.
Any opposed, any abstentions? What do you got? We're going to call a case out of order. Yeah.
Next, we're going to call case 39723 through 39823, North Belmore, Audrey M. Berger, known as Audrey Devaney. Mother-daughter residence, second kitchen, variance lot area occupied, construct two-story additions, both attached to dwelling, also known as 838 Leeds Drive. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Please take a seat, state your name and address for the record.
Morning, ladies and gentlemen. My name is Bob Clifton. I'm the architect of record. I'm here representing Audrey Devaney. She purchased the house in 1961. has lived there her entire life. We're here for two variances. First variance is for a mother-daughter application. As I said, she's lived there her entire life. She gave birth to Ryan. Ryan married Erin. Erin moved in with Ryan and Audrey.
Give us 1 second. Got the papers we need now. Go ahead.
Okay, so Ryan has lived there his entire life. He married Erin. Erin moved in with him. They've now had 2 children. And now the intention is to build a second story and create a mother-daughter environment. That's the first variance request. Second variance request is for percentage of lot occupied. 25%, 27.5% is what's permitted. What is requested is 27.7%. In terms of real square footage, it is 16.3 square feet over what is permitted, which is approximately 1/2 of this table.
But not a second story, a 2-story addition, right? On the first and second?
Oh, there's a little bit of, there's a small addition, partial addition on the
Okay,
first
so a
floor.
portion of it's over the first.
Correct.
The second kitchen is, this request includes putting in that kitchen? It's not already in?
No,
It's not already?
it's a completely new environment.
So for mother-daughter applications, the Board of Architectural Review always reviews them to ascertain whether or not the dwelling is suitable to be used in that fashion and suitable to be put back in the form it was in prior to that at the cessation of the use. They often make recommendations about changes that we advise of so that you have a chance to explain why that may or may not be an appropriate change or why you would not like to make it. However, in the case of this application, the Board of Architectural Review determined that the dwelling is suitable to be used as a mother-daughter unit with all the appearances of a single-family dwelling, and it's suitable to be restored to a single-family dwelling at the cessation of the mother-daughter use.
Correct.
In addition to that,
The clients have been provided with the conditions of mother-daughter. They're familiar with all the conditions. They're aware of the fact that the property must look like one family dwelling, 1 meter, and upon a sale or one of the parties moving out, the mother-daughter status will be revoked.
That's correct.
Okay? Can't be passed on to another buyer.
how many vehicles are associated with the household?
I believe that's on the site plan, but I believe we actually have an extra space.
Okay, I just want to put it on the record.
For the records, I believe there's 1 enclosed in a garage, and there are 2 outside.
So the family has 3 cars
Has 3
total,
has 3 parking
and
spaces.
all of them can fit off of the street if need be.
That's correct.
Also, I think the chairman may have covered it, but just to make sure, 1 doorbell, 1 meter, 1 main entrance.
That's correct.
Anything else you'd like to add?
I'm finished.
Mr. Chairman, I would move that the hearing be closed, that the matter be placed on the decision calendar. Everyone who did sign in will receive an individual copy of the board's decision once it's rendered. Thank you. Have a nice day.
Thank you very much.
Aye.
Have a great summer, people.
Thank you.
Next, we have cases 38323 through 38523. Belmore, Paul and Tracy Kuntz. Variance, rear yard, maintain second-story wood deck with stairs attached to dwelling. Maintain accessory structure, shed, not permitted in side yard. Special exception to maintain second accessory structure, shed, not permitted in side yard, also known as 2492 Coral Court.
I do. Tina Pangallo, 549 Hempstead Turnpike, West Hempstead, New York, 11552. Good morning, Chairman, members of the board. I'm representing Tracy and Paul Kuntz of 2492 Coral Court in Belmore. The property is located on the south side of Coral Court, east of Little Neck Road in Residence B. We're requesting a variance to maintain a second-story deck with stairs and 2 existing sheds. The second-story deck violates the rear yard setback required of 15 feet. The setback provided is 10 feet. The Kuntz purchased the house in 2004 with an existing second-story deck that was not in very good condition. They replaced the wood, reinforced it, and made it slightly larger. There are 2 existing sheds in the side yard that violate the requirement of being in the rear yard, and also 2 accessory structures. The first shed is 12 by 8, and the second shed is 5 by 8. The largest shed has been there since 2004, and the second shed since 2009. The sheds are used for tools, lawn equipment, that type of thing. The Kuntzes are selling their home to their daughter, and they would like to get everything in order, and we're respectfully asking the board to grant these variances.
Was it the sale, the impending sale that caused your clients to know they needed to legalize these items?
No, actually, the deck started way back in 2017.
Anything else, Ms. Pangallo?
No.
Mr. Chairman, I would then move that the hearing be closed, the matter be placed on the decision calendar. Ms. Pangallo, you'll be notified by mail of the board's decision once it's ready.
Thank you very much.
Aye.
Next, we have case 38623, near Westbury, Lenore A. Thal. Variance, side yards aggregate, maintain garage conversion to living space attached to dwelling, also known as 70 Palm Lane.
Peter Cinquemani, 75 Albertson Avenue, Albertson, New York. Good morning. I just want to give a little background on this before I get into what we're seeking here. The house sustained a major fire, and we filed to rebuild the home, and the garage conversion was previously approved in 2014. When we filed for the fire damage repair and to rebuild the home, it came to our attention that the 2014 approval was approved in error because they never came to this board for the side yard aggregate. So
they, in 2014, they got a permit to construct it the way it was with the garage converted, and did they close that permit?
it was closed. However, when we filed now, it came up that because when they filed that permit, it never went for a variance, that it was an error. So what we did was, in order to help our client to move forward with the rebuilding of their burnt-down home, we filed 2 permits. We filed one with the garage, as a garage, so that they could get a permit and start building, and we filed a separate application, which is here before you today, for the conversion of the garage to living space, which it was originally.
For that request, you're seeking a side yard aggregate
Correct.
with the conversion.
Yes, we do meet the minimum side yard on the garage side, we just don't make the aggregate.
What is required and what are you proposing?
The required is 15 aggregate, and I believe we have 12 and a half feet. Let me pull up the drawing quickly.
Do I have any other questions from the board? If not, do I have a motion?
I move that the hearing be closed, the matter be placed on the decision calendar. Sir, you'll be notified by mail of the board's decision once it's ready.
Thank you.
All in favor?
Aye.
Any opposed, any abstentions?
Next, we have cases 38723 through 38823. East Meadow, Louis Koss, variance rear yard, construct second-story addition, open below, attached dwelling, maintain 8-foot 8-inch high arbor, also known as 1784 Bard Lane.
Yes. Ken Schulman, 209 Lynn Avenue, East Northport.
All right. You're here for the second-story addition and the 8-8 arbor. Tell us
Yes.
about that.
Good morning.
Morning.
Good morning.
We are proposing a second-floor rear addition, which will be open underneath with a patio. The addition will require a variance for rear yard setback. We are proposing 13.36 feet, where 25 feet is the minimum requirement. My clients have resided in the home for 30 years, and after finally becoming empty nesters, their adult daughter has needed to move back into the house along with her 3 children. The Costas suddenly went from having 3 empty bedrooms to being in the need of 1 additional bedroom. I explored all of the alternatives on how to best situate this addition on the property. Since the property is only 88 feet deep and 87 feet wide, the allowable building envelope where we could expand is very limited. The original house has a 26-foot rear yard, allowing for an 11-foot deep, 1-story addition under 240 square feet with a 15-foot rear yard setback, but that would take up much of the small backyard they currently have. Because the property has one of the widest frontages in the 200-foot radius at 87 feet, it requires a minimum side yard of 8.7 feet and an aggregate of 26.1 feet. This wouldn't allow for an addition to the side without requiring a substantial variance that would greatly increase the bulk of the house from the street view to all of the surrounding neighbors. I believe the solution we are proposing for the additional bedroom was the best possible because it allows the Costas to keep the existing rear patio so they can still enjoy the outside and will not change the appearance from the front of the house. I submitted photos that show the addition wouldn't have any adverse impacts to the adjoining properties because the rear yard is very well screened from all of the adjoining properties by fencing as well as dense evergreens. I would also like to note that if the property was 100 feet deep, which many of the properties in the area are, instead of 88 feet, we would have a conforming rear yard setback of 25 feet. Lastly, we are seeking to maintain the 8-foot-high PVC arbor that acts as the gate for the 6-foot fence adjoining the garage side of the house. I think it's an attractive feature and has no adverse impacts to any of the adjoining properties.
Mr. Schulman, how many cars are associated with the family? We have a letter here from someone with the following comments. They're opposed to the application. No more bedrooms, already seems too many people living in the house with their cars a nuisance. Would only not oppose if they enlarge the parking area, all caps first, to accommodate all their cars.
There are 4 cars. They have a 2-car garage, and the driveway holds 4 cars. I believe they might park 2 of them on the street, but I don't think that's excessive to have 2 in the driveway and 2 on the street.
What are the ages of your client's grandchildren?
They are 16, 19, and 21.
Are they part of the cars already, or?
One. So the Costas themselves have 1 shared car. Their daughter has 1 car, and the 3 children have 1 car.
And the area below that's to be maintained is open?
Yes, it currently has I'm sorry.
On the proposed addition, was that area already existing as something beforehand?
It currently has the patio that we're going to maintain.
Okay, so that doesn't count in low area occupied, I guess, even though it has the second story down. Well, either way, you would reject it for that.
Yes, yes.
You're not here for that. Any other questions from the board? If not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Mr. Schulman, you'll be notified by mail of the board's decision once it's ready.
Thank you.
Thank you, have a nice day.
Nice day. Second, all in favor? Any opposed, any abstentions?
Next, we have case 38923, Oceanside, Farron Tomlinson. Variance, side yard, construct wood deck with stairs attached to dwelling, also known as 109 Elaine Drive. for the record.
Good morning.
Morning.
I'm Monty Leeper, located at 414 Foxhurst Road in Oceanside, and I'm the architect.
Lizelle Tomlinson, 109 Elaine Drive, in Oceanside, New York, 11572.
No.
Lizelle Tomlinson, 109 Elaine Drive, Oceanside, New York, 11572.
Farron Tomlinson, 109 Elaine Drive, Oceanside, New York, 11572.
Yes, Farron and Lizelle Tomlinson, who reside at 109 Elaine Drive, a 70 feet wide property in Zone Residential B in Oceanside, are requesting a side yard variance from the zoning code that requires, in this case, that the side yard be 5.8 feet, but is proposed to be 5.1 feet, a difference of 8½ inches under the Zone B requirement. The side deck proposed will replace the original landing and steps that were built with the house in 1960. Exhibit A, which I have here, shows the west side elevation labeled by the original architect as the right side. The original landing and steps was damaged by Hurricane Sandy. The Tomlinsons have lived in the home for 14 years, since 2009, are quiet neighbors who simply want to have a place to exit the elevated split-level home to the 4 feet 6-inch high deck from the kitchen floor level to the rear yard, take out the garbage and place a couple of chairs outside the kitchen to enjoy a cup of coffee before or after work. An added feature is that the proposed deck can act as a place for emergency rescue in the next flood episode. The home is located in Zone X, which is not a flood hazard zone, but is surrounded on 4 sides by Zone AE8 and AE9. The subject premises received 4 feet of water to the lower level during Hurricane Sandy, and my Exhibit B is a copy of the flood map showing the home's location. The permits obtained over the years, including the fence, shed, Sandy repair, have been closed out, and the Tomlinsons will close out this application as soon as possible. The permits obtained over the years, the proposed deck complies in all other aspects except that the 8.5-inch variance request and the deck and home will be kept in impeccable condition. It is located behind hedges, 6 feet tall PVC fences, enhances the home, does not impose on access to the rear yard for emergency rescue equipment because the remaining side yard is 5.1 feet, is not a detriment to the neighbors of the surrounding neighborhood and will not block sunlight or adversely affect the health, safety, or welfare of the adjacent properties. And for these reasons, we respectfully request that the variances be granted. And that's our case.
Step up
Do I give these to you?
to the podium.
How far does it go?
Where does it go up?
Good morning. My name is Susan Eisner. I live at 119 Elaine Drive in Oceanside, New York. I'm here today with my husband, Ari Rosenbaum. We'd both like to address the board in opposition to the application for a variance. I have to say I object to most of what Mr. Leeper stated on factual grounds. I'd like to begin by just addressing the board with respect to whether this case should be considered a nullity and stricken from the calendar. I would like to point out that the affidavit of serving notice that is part of the application is invalid because it was not properly notarized. According to 19 NYC RR 182.3A5, a notary must disqualify themselves from performing a notarial act for a transaction in which that notary is a party or has a direct or pecuniary interest in the transaction. The affidavit was sworn to by Mr. Leeper, and it was notarized by his wife. It's my understanding that both Mr. Leeper and his wife are parties or principals of the architecture firm, and I have a photograph establishing that, if I could share that with the board.
Can you just give me the citation again?
19 NYC RR 182.3, subsection A5.
1982, 19 NR.
NYC RR 182.3, subsection A5. I can actually share with the board a copy that I printed out from, a copy of the statute, if you'd like to see it.
Good. If you'd like
Very
to
well.
offer it in evidence, could you please show it to Mr. Leeper?
I'm sorry, I couldn't hear that.
Could you please show it to Mr. Leeper?
And I also have a picture that I could share.
You can also show that to Mr. Leeper?
Absolutely. Here you go. And I have the affidavit of serving notice for the board's reference, if you'd like to, or convenience, if you'd like to see it now.
Okay.
There are actually also other documents in the file for the variance application that were notarized by Mrs. Leeper. So it's our position that the entire application is a nullity, and that it would divest this board of jurisdiction to hear the application.
We'll consider that. but
Thank you.
We're going to proceed. What else?
Okay, so as to the merits, it's my understanding that there are 5 factors that this board is required to consider on an application for a variance such as this, and I'd like to go through all 5 of them and explain to this board how the application violates each of them. The first factor, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance. So there's 2 parts, and I'll address both in turn. With respect to undesirable change in the neighborhood, this board should understand that Elaine Drive is 2 blocks long. There are 47 houses on the block. These homes were all built on or around 1960, as was mine. And they're built in the style of lanai high ranches. They were kind of a builder special, if that term is familiar, so that they were all built in the exact same style. 2 of the homes on Elaine Drive were rebuilt into different styles. There's 1 on each block of Elaine Drive, and 45 lanai high ranches remain. There have not been any permits or variances granted for any of the homes on Elaine Drive for the kind of party deck that the Tomlinsons are seeking to build. No permits or variances, so granting this variance would set a precedent, and in my position, a dangerous precedent. The way that these lanai high branches were built leaves a very, very narrow side yard. So, and I have pictures to show you on my property what it looks like. So it's clear, at least from these pictures, that nothing was intended to be built in these side yards. The original homes were constructed with a very narrow staircase that provided egress from the second floor kitchen to the side yard, and the staircases would lead people who were descending the staircases out to Elaine Drive. So all it was simple egress. And the narrow space is really used by all of the neighbors on Elaine Drive for, our air conditioning condenser for central air. It's a place to put your garbage pails. It's a place to put like outdoor storage boxes for if you have pool toys or anything like that. And I can share pictures with the board if you'd like to see it.
If you'd like to offer those in evidence, you can. Please show them to Mr. Leeper first.
Well, I have several. Let me just see if I can choose the best ones. Well, actually, here's one from my yard that you can see. What I'm showing you is my yard. And I mean, my yard is not qualitatively different. My side yard is not qualitatively different from the Tomlinson's yard. So you can see, I think we measured it, I think from my home to the fence that the Tomlinsons erected is about 5 feet. And actually, I should also point out, before I go further into my argument, that the survey that was submitted with the application for a variance is based on what appears to be a 1959 survey. The situation on the ground is very, very different. The Tomlinsons erected a fence in 2013 I believe it was June of 2013. That fence is not on the property line. So I just want to be very, very clear that to the extent that measurements are being made to the property line, that's not actually what's going on the ground.
Which property line do you refer to?
The Tomlinsons erected a fence not on the property line, but on their property.
Wait, but on which of their I don't know which side of their house you're
I'm sorry, forgive me. When I explained earlier about the houses on Elaine Drive, my house and the Tomlinsons' house are mirror images of each other. So the area where the Tomlinsons are proposing to build a party deck is actually adjacent to the side of my house, so that our kitchens face each other, our bathrooms on the second floor face each other, and our master bedrooms face each other. The windows are facing each other.
Hold on. Mr. Leeper, is this deck 3.4 feet wide and at its proposal 22.23 feet long? Is that the proposed deck? .4 feet wide.
3.4 feet wide, yes, and
22
22.23 feet long.
That's the deck we're talking about, you're also referring to.
Correct,
As a
yes.
party deck,
Yes,
okay.
I'm sorry, that's the only deck.
Well, I get it, but it doesn't strike me as a party deck because it's so small. So that's why I wanted to make sure that I'm talking about the same deck.
Well,
Okay.
I mean, you'll understand further when I get to my subsequent argument why it's a party deck, but yes, it's a deck.
Okay. And if I heard you correctly, they're proposing to reduce their side yard to 5.1, and yours is roughly the same, 5 or something.
I think, I'm not an architect. I think that I guess what I'm saying is that their deck, the deck that they're proposing to build is going to be far closer to their fence than the survey would indicate, because they're basing their measurements on where the property line is, but that's not where their fence is. Their fence is closer to their own property.
So that would mean that the deck, go ahead, Mr. Chair.
go ahead.
That would mean that
You're going to say the same.
that the 5.1 assessment of the side yard provided would actually be an underestimate. The side yard they would be providing would be greater than that.
I think that they would be over more than they're advising this board that they are.
Over what? Closer to the property line?
Yes.
But if their fence is on their own property, and they've measured from the deck to the fence, and that comes out at 5.1, but there's still a little more of their property on the other side of the fence, they would actually be further from the property line than this number indicates.
No.
Why not?
I guess what I'm saying is it doesn't matter. The numbers aren't changing. It's just when you look at it, it's going to be much closer to their fence.
Only because the fence is
Correct.
closer to the deck or to the house. But the
Correct.
reality is, this 5.1 number then would be an underassessment of the actual distance from the proposed deck to their property line.
They're measuring from their property line. The fact that the fence is closer just means the deck is going to be closer. It doesn't change the number as far as their measurement.
Okay, keep going.
As I was explaining, the narrow side yard, it's a very narrow side yard, and so when these homes were originally built, what happens is they were built with a small staircase, and Mr. Leeper mentioned that it was damaged during Hurricane Sandy. Hurricane Sandy, as we all know, was in October of 2012. The staircase continued to be used by the Tomlinsons up until the early part of 2022. So the staircase continued to be used by the Tomlinsons until early 2022. So it was there even after they replaced the siding for their house, and I have pictures of that. The staircase was only removed in early 2022 when they undertook to file a application for the variance. So the staircase was functional in every respect for more than 10 years after, or almost 10 years, I should say, after the hurricane. It was about 6 months short of 10 years.
How much wider, if you know, is the proposed deck than was the staircase that was there?
I can't answer that, but I do have a picture of the staircase on the Tomlinsons' house, if you'd like to see it. There, it looks like it was built with cinder blocks. And I don't know if there's a standard measurement for these kind of blocks, but I have a picture of what it was.
Okay. Now, when you say the mirror images, obviously there's slight distinction because you were on a corner lot, but that would only pertain mostly to the other side of your house. But as it relates to this shared property line, do you also have a staircase there like the one they had, I guess?
We removed the staircase years ago when we renovated our kitchen. So we removed the door, and what we have instead is, we built a pantry cabinet for our kitchen because the kitchens are unfortunately very small. So I don't have that staircase anymore.
So when you estimated your 5 foot from something to your property line, in other words, your side yard on that side of your house, was that from your house?
Yes.
To your property line, 5 feet?
Yes,
Okay. And Mr. Lieber, you have 8.4 feet from the house to the property line? Yes, I'm looking at the materials.
I have 8.55 feet from the calculation of the survey.
Well, this says 8.4, but
On my side-
at any rate, so that would be, if you,
It's-
so
I'm
the
sorry.
old staircase probably, so when your staircase was in, you probably had about 2 feet to the property line, but you removed it anyway. So I'm just trying to figure out the houses, because yours is set closer than theirs is. And
yeah, I mean, the truth is, I really don't know, honestly.
Okay.
Taking out, because that's where we used to keep our garbage cans, and that was always, you know, as far as shared responsibilities, that was something that my husband did. I don't even think I barely ever went out to the side yard.
so you removed your door from that side.
Correct.
All right, keep going.
Okay.
Thank you.
Well, actually, can I share these pictures with the board, just to show you what the staircase looked like up until
Okay.
2022?
Yeah, just show them to Mr. Lieber. Were these photographs taken by you?
Yes.
Okay.
Everything that I'm sharing with you is taken by me.
Fairly and accurately
Yes,
portray
absolutely.
that which they purport to
Absolutely.
portray.
These were all taken on my iPhone, so, I mean, if the board would need metadata, I can certainly provide that, but I tried printing them out as best I could on a color printer. Actually, here's a few more. These actually are better pictures. Oh, I have no shortage of pictures.
Just relax.
Well, some of them may be better. It's an occupational hazard. Here's a good one. Here's a couple of good ones. All right, I promise this is my last one. Okay.
Do you want to see any of these?
I'm trying, it's hard.
Yes, I have seen these materials. No objection?
Okay, and so to the extent that Mr. Leeper stated that the staircase was damaged by Hurricane Sandy, when the Tomlinsons replaced their siding, and I believe it was in 2013, the staircase was actually improved with a PVC railing. So, I mean, the staircase continued to be in use. I mean, I know this because, like our garbage cans are stored there, the Tomlinsons also store their garbage cans there, and I hear them banging their garbage cans at 11 o'clock at night, using the doorway to get out. Up until last year, when they removed the staircase, I would hear them at 11 o'clock at night banging the garbage cans when they went outside to put their garbage in. So
Okay.
the staircase was, I don't have a picture of it, unfortunately, but I'm testifying here that I personally observed a PVC railing improved on that staircase that was there up until the early part of 2022.
Okay, I mean, to be perfectly honest with you, I can't speak for everyone, but it doesn't matter to me that, in that, I think we look at this request on the merits and whether the staircase, for whatever reason the staircase was removed, I don't personally find it too relevant to us, to my consideration anyway, of whether or not this is appropriate structure to allow on the premises. And
Understood.
I did want to point out one thing. Ms. Adams was reviewing the map of the area, as we often do. It looks as though there's a house, 6 houses to the east, with virtually the identical request that is being made here. I don't have numbers, but it's a long, narrow walkway on this side of the house. But I don't know the address of the premises because I don't have the addresses, but it's the 6th house east. So it looks to me like that would have required a variance. I can't say not having numbers in front of me, but I don't know if that was included in your analysis as to the block Elaine and the other block would be similar, would be identical. Or basically all but 2, I think you said 45 identical houses and 2, 1 on each block that were different, but that would be worth taking a look at.
So it's my understanding that if there are any of the kinds of decks that Mr. Tomlinson is proposing to build, they don't have permits and they don't have variances. My husband actually went to the building department to check the records, and according to the house that you are referring to, there is no permit and no variance ever granted for it. So again, it's my position that granting a variance in this case would be unprecedented on Elaine Drive.
So you know the house I'm talking about, sounds like. You know
Yes.
which one? Okay.
Yes.
Well, good, I'm glad I mentioned it so you could address it.
And it's my understanding that it's an illegal structure.
Okay.
So that granting a variance in this case would be the first permit, or I'm sorry, the first variance requested, because this is clearly in violation of the existing zoning regulations, and so a variance would be required, and granting a variance in this case would be the first of its kind for Elaine Drive, and the kinds of houses that 45 out of 47 of us have. Let me see. So I was addressing the detriment to my home, and I just want to be clear. Mr. Leeper described the Tomlinsons as quiet neighbors. That has not been my experience. My husband and I have lived in our home since 2005. We bought the house in 2005, and we've lived there continuously ever since. We live there with our 2 minor children. The Tomlinsons purchased their house in 2009, and they have frequent parties. They're very, very loud neighbors. They've never once told us, given us like a heads up that they're going to be having a party. They have parties. They have currently 4 cars that are 4 cars for the occupants in their home. When they have parties, there's a lot more cars. They park in front of our house. They've blocked our driveway where we couldn't get out of our own driveway because their cars were parked there. The parties are very loud. They use speakers and amplifiers. Recently, one of their sons apparently learned how to play the guitar, or he's been playing the guitar in the backyard. And, you know, these lots, as you can probably tell, are fairly small. These are not large properties. So, you know, playing the guitar in the backyard, I mean, people at one end of the yard can hear it if the player is at the other end of the yard, but yet they use an amplifier.
What makes you believe that this little gangway would become the party area if they still have the yard they party? Because this isn't taking up that space.
But it's making more places for people to congregate. It's going to be right outside of the kitchen, so this is where people congregate. I mean, they've already said that they plan to sit outside. And let me point out, I mean, I don't know if it's apparent. I mean, I have another picture just showing the houses, but it doesn't necessarily show. When I say that our houses face each other, I mean, when they're sitting outside on this deck, they're going to be right outside of my bathroom window. They're going to be right outside of my kitchen. They're going to be right outside of my master bedroom. I mean, this is going to eviscerate any sense of privacy that I have.
But it looks, by looking at the map, it looks like your house doesn't face theirs, but rather it's actually the back of your house that is on the side where they proposed this walkway.
Okay, I have more pictures. What's hard to understand is that the way that these houses were built, they were built like in pairs, so that it's like there's a pair, then there's another pair, and they face each other. So the front of the house doesn't face Elaine Drive. The front of the house is like perpendicular to Elaine Drive.
Right, the front of your house, is it on Fulton Avenue?
No, my house is redesigned. I have an added ground level, like, I built like an expanded entrance so that my front door faces Elaine Drive. The Tomlinson's house, their front door faces, I guess it's Lawrence Avenue. It faces down the block.
Your front door faces Elaine Drive.
Mine does because my house was expanded.
Oh, because it doesn't actually look like it on the, you know, when you look at the satellite view, because there looks to be a
Well,
portico.
here, I have another
facing out
picture.
to Fulton Avenue. I can't even see a walkway on Elaine Drive.
Okay, I have a
But-
better picture here.
Yeah, maybe it's,
This is my house, and this is my front door. Normally, the front door would have faced that way. So I rotated it 90 degrees, if that makes sense. And
so that portico that juts out toward Fulton Avenue, even though it looks from an upper view, now we have the 3D view, there's that, you pull your cars in off Elaine Drive and then you walk into sort of this, from the side facing Elaine Drive is where the door of that portico is, I guess.
for my house, when you pull your car into the driveway, the front door is facing you. The Tomlinson's house is different. When they pull into their driveway, their front door is on the right. So they have to get out and turn to the right.
I see.
Okay. I have another picture that'll show you. I mean, I've never seen like any style of this house before I bought this house. It's quite unusual. Here's more pictures. I mean, my house is the beige house on the right, and the Tomlinson's house, this was like a yellowish color siding before they... I'm giving you everything I have. No, I guess not. I think that's it. I'm getting
Okay, you can continue, Ms. Eisner.
Okay, thank you. No, so I just want to stress the point that, I mean, to have somebody sitting outside of my bathroom window, I mean, you know, they say it's going to be for like sitting outside and having coffee, but either way, when they have guests come over for a party, guests can stand outside, and they're going to be feet from my bathroom window where I shower. I mean, people are going to be at the same level, standing at the same level that I'm standing when I shower in my bathroom. People are going to be standing a few feet away from the window to my master bedroom. People are going to be standing a few feet away at the same level as my kitchen when I'm eating. I mean, I didn't buy a house in Oceanside to be able to have people living right on top of me, and that's really what this is. I could have stayed in Brooklyn and Queens for that. I wanted to have some space from my neighbors.
Is there anything else you'd like to add?
So yes, now, if the board doesn't have any questions on that, I'd like to move on to the second criteria that this board is considering on the application for a variance, whether the benefit sought by the applicant can be achieved by some other method feasible for the applicant to pursue other than an area variance. It's my position that the Tomlinsons could proceed without the need for a variance by replacing a staircase similar to what the house was built with, and they could even have it facing the backyard. There's no reason to construct a deck right alongside my house. They could put back a simple staircase. It wouldn't have a place for them to sit, but they'd be able to sit right outside at the bottom of the staircase. They could walk down 4 steps or whatever it is and sit outside, you know, in the side yard. They'd be hidden from my view by a fence, instead of having them at the same level as my master bedroom, my kitchen, and my bathroom. It would be far less costly than building a deck. Just replace the stairs that the house was built with. We have no objection to that. I mean, the point is, if you're looking for simple egress, put a staircase back. There's no reason to build a deck and inflict yourselves on me and invade my privacy, which is exactly what this deck would be doing, because you're putting people at the same level as some of my most private spaces.
Yeah, I think they said they're not looking for simple egress. They want a place to sit out and have coffee. So, I mean, I agree with you. If they were looking for simple egress, it would be achieved in a different way, but I think
I understand that,
testimony
but-
was they're not looking just for egress.
But their desire for this extra space is coming at my expense, and at the expense of the places in my house where I most want and deserve to have privacy. In my kitchen where I eat, in my bathroom where I shower, and in my bedroom. To point 3, whether the requested area variance is substantial. Again, it's my position that it is, because none of the 47 houses on Elaine Drive have ever been granted a permit or a variance for the kind of construction that the Tomlinsons seek. As far as the 4th point, whether the variance will have an adverse impact on the physical or environmental conditions in the neighborhood or district. I'd like to address the issue of the fact that these houses are situated on low-lying land, and we have a very high water table. Mr. Leeper explained to the board that there was flooding from Hurricane Sandy. There absolutely was flooding, and as a result of that flooding, my house actually had more than 4 feet of damage. I'm on the corner, and perhaps my house is on lower-lying land. I don't really know, but I do know that we were forced to install a significant drainage system in our home. So on the side of my house that is going to be abutting this deck that the Tomlinsons proposed to build, that's the lowest point of my house. And on that same wall that faces the fence, I had to install a French drain as well as a sump pump. The battery for the French drain, according to the manufacturer and for the company that we hired to install it, has a lifespan of 10 years. We've had to replace the battery after 5 years at a cost of almost $1,000 because the water table is so high and there is so much that the drainage system is so heavily taxed by this water table. So every time there's rain, we get water. And I am extraordinarily concerned that by the construction of this deck, which, as I understand, is going to have some kind of concrete pilings, it's going to disrupt the soil and cause even more, cause my system to work at an even greater effort to repel the water that's coming in. Because, I mean, I hear it downstairs. It's constantly running. Anytime there's rain, my system is pumping out water. And by dislodging the soil, it's going to put even more pressure on our system. So now, where I have to replace the battery that's supposed to last for 10 years, after 5 years, I may have to now replace a battery after maybe 2 years with this deck being installed. All I can say is that when we expanded the front entrance of our home, I mean, I don't even know what the square footage is, but it's a decent-sized space. And the architect that we hired at the time said that to install that we should not use concrete pilings, that helical piles were preferred. And again, I'm not an engineer. I can't speak to the technical aspects of these things, but, and I know that that a deck is not the same thing as an addition to the home. But my point is that, you know, these concrete pilings are going to disrupt the soil, and it's going to have an effect on the water table. And the effect on the water table is going to be detrimental to me, because my system is going to have to work even harder to repel the water because there won't be the soil there. And again, I have an invoice if you'd like to see it, just to establish the fact that I do in fact have these drainage systems in my home. Would you like? Okay, no, but I mean, I brought the invoice to show you. I mean, this is, I'm speaking, and, you know, I've had the battery replaced, because again, I mean, and we didn't spare any expense when putting in this system, because, you know, we lost everything in Hurricane Sandy. Like, I have no childhood photos. I mean, the entire lower floor of my home was destroyed. So I have nothing left from that. So, you know, it was in our interest to make sure that something like this never happened again. So we spent top dollar to put this drainage system in, and now it's going to all be for nothing, because there's going to be no soil next door, and it's going to move everything to my house. Because again, I got much more than 4 feet of water, so my house is clearly situated in a way that it's more vulnerable to the water conditions. And forgive me, I mean, this is not my area. I don't know about this, but all I know is I got water, and I don't want to have water again. And the other thing I would point out is that, you know, as a layperson, and again, I mean, I have no engineering background. I don't know, I'm a lawyer. I don't know anything about any of these things, but I will tell you that the whole notion of having a wooden deck so close to my home is really scary. After Hurricane Sandy, among the other repairs that we did was we replaced the electrical. So we got a brand new panel and we got all brand new wiring, and that was done at great expense. And I remember having a conversation with Mr. Tomlinson about that, and he told me that he wasn't replacing his electrical, and he has apparently an uncle who has some kind of an electrician's background, license, practice, and he didn't replace his electrical. So like every day since then, we live in constant fear that his house is going to go up in flames. And now there's going to be a wooden deck extension on his house that's even closer to my house. So how much scarier is that? I mean, everybody I know on Elaine Drive replaced their electrical. I was shocked when he told me he didn't. If he's done it since then, I don't know, but I live in fear that his house is going to go up in flames, and now his house, by virtue of this proposed deck, is going to be even closer to mine than it was before. I mean, we're terrified that it's going to go up in flames. And as far as the fifth criteria, which is whether the alleged difficulty was self-created, I would point out that there was a staircase there. It was in use for more than 10 years. I mean, he removed it. I mean, it's his choice to remove it, but the fact is that this doesn't need to be this way. He could very well put like a patio on his side yard. I mean, he clearly has much more space than we do. He could clearly put a patio on the ground level and have a very nice place to enjoy the coffee. There's no reason to do this, because the burden to us is outweighed by the benefit to him. Unless you have any questions, I'd like to give my husband an opportunity, because I'm sure I've overstayed my welcome at this podium. But thank you.
My name is Ari Rosenbaum, 119 Elaine Drive in Oceanside, New York. My wife, I'm going to speak a lot, I'll be a lot more brief than she is. The fact of the matter is, if the idea of a side deck is to enjoy coffee, the backyard, he has a wonderful backyard, much nicer than ours. We've fixed up our backyard as well. The deck is really a mechanism to transport his guests from the living room / kitchen to the backyard, rather than going downstairs and exiting through what we call the lanai room. The lanai room in Lanai Ranch is the room that has side windows to the backyard. And that's merely what it is. It's a allowance for the guests to go from the front to the back. And again, as my wife stressed out, the deck is 10 feet from my bathroom window. The end of the deck where the stairs go is 10 feet from my bedroom window. It is more than just a place to have coffee. Again, it is a way for his guests to go from the kitchen area to the backyard, rather than having to go downstairs and through living space and going through the lanai room out. That is all that it is.
Wait, now I'm confused. If the concern is that it's a way, I happen to think you're probably right. When I look at it, I think your assessment is probably right. It looks like a way to come out, walk down the the gangway, whatever you want to call it, and go down. I think front and back has stairs, and as they've said, they also want to sit there and have coffee. I happen to think you're right. So if the concern is that rather than use that as the way to get to the backyard, they should use the other way that is available, I get it. But that's a different concern than one thinking it's going to be a party deck, because I frankly don't see it, how a 3 feet 4 inch wide
Three feet.
gangway is a party way. I mean, I don't even know how many, I could see a chair fit in there, but frankly, even with the chair, a bistro set, you can't even walk through, so I think that your concerns are different than your wife's. And I think, I think the way you've stated this use to be proposed is, other than adding, we'd like to drink coffee out there, I think that looks to me more like what this thing would be, to that extent. But, keep going.
Go on.
Again, these are nice people. I don't have, their guests are a whole different sort. I can't, police their guests. It's an area 3 foot wide. People just would hang out and whatnot.
Go on.
So that's, again, the houses were built on effectively sand. She says they got 5 feet, we got about 8 feet of water, 3 feet that came through the front door to hit the second step of our living space. There was a point, because we didn't heed the evacuation call at the time, there was a point that I was going to actually go into the crawl space and hide out there, because I didn't know how high the water is going to be. And my concern is that with the cement pilings, that it's just going to further displace water, that's going to put maximum, and the water tables have changed. So for example, after the hurricane, we had an existing French drain. We added a sump pump to the front of the house. Now, the sump pump was never in use unless there was a massive rainfall. We've had, nor'easters and whatnot. But I've noticed that every single time it rains, the sump pump now is in use. So it's pumping water out to the street. The French drain is in the back of our area over there, right abutting the backyard. That's been overtaxed, and that's what my wife has been talking about, the battery that has been replaced. But I believe that, a design of a side deck with not helical piles, with actually concrete pilings, is going to further displace water, because effectively, like I said, this area is built on sand. We learned the hard way in Hurricane Sandy, because the water most of the water came up through the floor. There was a point, it was something out of Poseidon Adventure, where I was just tri-vacuuming water that was coming out, and then all of a sudden the water came out through the vents in the downstairs area that we've had to replace. And I understand why they want to do this, but I understand my reasoning to stop this, because I believe that it violates my rights as a property owner to enjoy my property, to have the right of quiet enjoyment. And I've been here 18 years. I will not be here in 18 years. I plan on leaving eventually one day. I don't know when. It's going to further hamper my ability to sell this house, because I'll be the only house on only lanai house with a next door neighbor that would actually have a legal side patio. Thank you.
Thank you. Mr. Leeper.
I could address each of the points. I think that it would take a very long time to do so, so I want to try to be brief about some things. As far as the sections from the code and notarization is concerned, I verified with the town of Hempstead years ago with Charles Covett in the legal department about what constituted a correct use of the notary versus incorrect, and was told that we were attesting to a signature and nothing else, and that the issue that was brought up today, I believe, is the same issue that I discussed with several of the attorneys. I know this board is well aware because I've been before this board with several different attorneys and had the same conversation about whether an employee who also has something to gain in their office, or they should be able to notarize their own client's signature. And they have all informed me of the same thing, that we are attesting to a signature and nothing more. And even though I understand the point, unless we're going to change this entire procedure, I have been doing this way for at least 25, 30 years with this board, and it has never, ever come up before.
Attorneys often notarize documents, and if we wanted to make the analogy that the attorney's getting paid for the legal work on the transaction, obviously that wouldn't, that analysis can't hold, because attorneys regularly notarize signatures of parties to transactions in many different forms, even though they're getting paid legal fees for their legal work on it. So I don't think that the role you played, to me, it's analogous and it's allowable.
Well, I don't want to debate that. I deal with a different part of the law. Those building codes are laws, and again, if that's the decision of the board that we have to find a different procedure, then I would hope that that's going to be uniform for basically everybody that comes before this board from now on. The next thing is, as far as some of the statements that were made, I think I want to start with the concept of displacement. I believe I'm actually technically one of the only people here who's licensed and qualified to even discuss whether a concrete pile versus a helical pile. None of them are even being used on this deck. These are 3 feet deep, actually 4 feet deep, because we go just below the frost line, and they're footings, not piers, and not piles. And the concept of whether they're metal piles or concrete, and the issue of displacement that was stated here, actually, unfortunately, is so minor, and it's a fallacy the way it was put, because it wasn't put by a professional, and I would ask that it be disqualified.
Give us a one-sentence description of the difference between a footing and a pile.
Okay, a pile is something that is pounded down or forced down under very high pressure till it reaches a point of what is called refusal. In other words, where it cannot go any further based on the resistance that's put on it. So if, for instance, 40 tons of pressure is put on it, it reaches a point where either bedrock or something else resists it to a point of 40 tons.
Okay.
This is not the case. This is not what we're talking about here. And a simple glance at the plans would show that.
And a footing is what? One sentence.
A footing is basically to set it into the ground so that it resists uplift due to frost.
Dig a hole and you pour in concrete, or what?
That's correct.
Okay.
Or we actually now have the ability to put a simple treated wood post in with a waterproof coating on it that can rest on a rubber pad, and it has to be of the right dimension according to section 504 of the building code.
Okay.
So, but that's not what we chose here.
Okay.
And it has nothing to do with displacement and pumps not working 10 feet away or anything else. If that were the case, there would be a serious problem even building a subdivision anywhere. This neighborhood, it was never taken into consideration. The other thing is that one of the reasons for the width of this deck is, if you take a glance at the plans, there is a rail on the deck, which is required, and by the way, was required even when the deck was the concrete. block deck, which actually displaced more than this deck would, because it was a solid feature on the property. But putting a rail back on it, to me, is a matter of safety, and it had to meet the building code. So whether they replaced their crumbling concrete block original steps back then, or chose that it wasn't financially feasible until now, was their business.
It's
But
not relevant.
I just wanted to point out, because I also believe it was not relevant. The property line issue and the false statement that was made about measuring to the fence, we didn't measure to a fence. We use surveys, and we use distances that are given to us in a legal survey. And by the way, the distance on the site plan is correctly shown as 8.55 feet at the front and 8.4 feet at the rear, because the house is not exactly parallel to the property line. The issue of whether other houses in the neighborhood do have stairs like this, I haven't worked on any that have a deck like this along the side. But I actually have worked on both Elaine Drive and Irma Drive, the street over, with houses where they did renovations to their kitchens. And I noted that they also had these side stairs. So it's a fallacy to say that there are no side stairs within this area, because I have personally worked on homes that had these side stairs. I am familiar with that.
Mr. Leeper, I don't think she said there were no side stairs. I think her issue was the deck, the long deck, if we will, like, is your client's, just quickly, is your client's fence on the property line on that side of their house, if you know?
I don't know the answer to that. We'd have to have a survey.
That's taken care of, if so, but keep going.
We would have to have a survey for that. I do know that it has already been signed off and received a final certificate of completion. And that's our case. Oh, I do want to ask my clients to state, just to answer about their loud, obnoxious parties.
Good morning. I just want to point something. Okay, I'm sorry. Okay. When we moved there in Elaine Drive, we know it's a really, really beautiful neighborhood in Oceanside, because most of my families live in Oceanside. And we've known our neighbors since we moved in, but during Sandy, there were witness that, they're all the witness that when they needed help, we were there, you know. But aside from that, when she mentioned about we always have parties, we have parties when we celebrate birthdays, graduation. We don't party every weekend. We're not party people. I have gatherings for birthday celebrations, for barbecue, but I've never had, even if they don't have that, if they don't have party in their own house, that's fine. But we always follow the time, and we're not loud. Of course, my son plays guitar, but we know what the law is. We know when to stop when we have the party in the backyard. But we never had any complaints. We are friendly neighbors. Our neighborhood, we all know them. We friends with them. Nobody complains with us. Nobody calls for us for complaints. No, because we are friendly neighbors to our neighbors. And regarding the party deck, that's not a party deck. We're in that age right now that we need access to the backyard easier, because the Lanai High Ranch is going steps down and going to the backyard. And that access that's not a party deck, that's an access go to the backyard. And it's easier access once we get to this age, you know, and it's also for my, you know, like safety. And, you know, I can't be going back and forth doing the laundries there, but it's just that's not a party deck. And I even have bushes because we want privacy. We even have bushes right in my kitchen window. We always close the blinds, and I have the kitchen bushes to make sure. I want privacy, and also because I love to cook. I like to close my kitchen window, my bathroom, and and my bedroom, that's all closed. We don't even, that's privacy, I'm very concerned about that. And that's not a party deck. And regarding, I just want to point it out, that's why we have a variance, because when she meant, I know during Sandy, I know when my husband mentioned about the electrical, we hired Barrett Electrical Company, because we upgraded all our electrical in the house. Safety is our main thing, because I have a family, I have 2 boys. You know, it's not, you know, we always have to code. So that's why our electrical is, because my uncle works for Barrett Electrical, so I know how she came up with, we do. And I just want to point out, but I'm just so shocked that, you know, they're opposed, but believe it or not, with privacy, I'm so keen with that. And then also, that's not a party deck.
Thank you. Okay, so do we have any other questions from the board? If not, do I have a motion?
May I just add something? Very brief. When we moved in that house, the following year, after purchasing that property, we had a little flood in the back corner. That flood came from the discharge of the pump that she's talking about. That cost them enormous money. Meanwhile, at that time, the discharge was just directly across from my window. That's the first one. During Sandy, the woman actually came into my house while I'm having dinner, twice, begged, kneeled in front of me to assist them, because I'm the only one that has generator in that 2 blocks of that neighborhood.
All right.
And all of them, I helped them out.
With all due respect, I don't think that is germane to this application, so we're going to close. Okay, we're going to close the hearing.
Mr. Chairman, I would move that the hearing be closed, that the matter be placed on the decision calendar. Everyone who signed in on the case will receive a copy of the board's decision by mail once it's rendered. Thank you all for coming and participating. Have a safe home. Enjoy the remainder of your day.
All in favor?
Aye.
Next case.
Okay, take a short
You
recess.
need it? All right, we'll take a 5-minute break to allow Stephanie to repair her fingers.
Okay, next we have case 390-23 Franklin Square, Dina D'Agostino. Variance, lot area occupied, construct addition, and stoop both attached to dwelling, also known as 138 Cruz Street. Dawn, this is the one we don't have anybody sign.
Yeah.
Second call? Okay. We'll find out. Yeah. It's going to be on the file.
D'Agostino.
Okay, next we have case 391-23, Merrick Jeff Diaz. Variances, height, side yards aggregate, maintain first story, second story, and two-story additions, all attached to dwelling. Variance, side yard, maintain 2 AC units, both attached to dwelling, also known as 59 Beverly Road.
Thank you, and good morning, members of the board. Mr. Chair, my name is Mark Anthony Monastery, architect, and my office is located at 1563 Belmore Avenue in Belmore. And today I'm representing the owners, Mr. and Mrs. Jeff Diaz, who are the owners and occupants of the subject property. This morning, requesting variances to maintain several items, all that pertaining to an original construct permit from 2001 under permit number 2001-03698. That was never closed out. Our office was the architects on that project in 2001 for the owner at the time to expand the first floor, multiple first floor alterations, and to add a second story to the, at that time, ranch-style home. Since that time and during construction, several minor alterations to the original plan were made. Although minor in each item, a determination by the building department and the BZA was made, mostly because of the timeline, to submit instead of an amendment to the original permit, but instead a new permit for the alterations was made. My office was hired after the sale was completed to the new owner, the Diaz's, who would like to legalize the house and close out all the permits. After multiple discussions and submissions to the building department and the BZA, it was determined that we... Sure. Sorry. After multiple discussions and submissions to the building department and the BZA, it was determined that we are filing to legalize the entire house as if it was newly built, at least the additions. Basically, this permit is going to override the original permit from 2001. Now, this all started, like many legalizations, when the new owners applied for a pool permit. Our first request is to increase the height from the permitted 30-foot max to 33.12 feet. This is just over 3 feet higher than permitted. At the time when the house was designed and built, the code for height was to the midpoint of the highest rafter, and this was legal at that time, and I can assure the board that the roof structure has not changed.
Okay, say that, let me just make sure. So approved in 2001 at this height, which was, they used the average back in 2001. It was approved at this height and built at this height, and that has not changed, but given the change in the code we had, whatever, in 08 or whatever, we changed that.
07.
We now need a height
The
variance.
overall application will require a height variance.
You are correct.
Are you in the FEMA zone area? Or
No. No, it's
Crown.
north of
312 from the crown, from the grade, what are you?
top of curb.
Pardon me?
Top of curb.
Wait, no, from the crown, which was our measure back then,
Yep.
and now, I guess, still, in cases not FEMA, you are 3312. From grade, just because it gives me a visual, from grade, what are you, if you know?
So I think what you're,
6 maybe?
we were under 30, correct.
Okay,
It's not a very high-pitched roof.
I see, go ahead.
Our second request is to reduce the side yard and combined side yard. On the original plans, an electric fireplace was designed in the living room. During construction, this boxed-out unit was pushed out flush to the interior wall, making less than permitted side yard. Our request is to reduce the side yard from the required 5 feet to 2.18 feet, and to reduce the combined side yard from 15 to 10.49. Lastly, we would like to maintain the 2 AC units on the side yard with a side yard of just over 2 feet where 5 feet is required. In closing, I would like to just once again assure the board that all these modifications were made over 20 years ago, and they have had no complaints from any of the neighbors. There is an open permit for a pool, which is what spurred all of these legalizations in the first place, and all of that will be closed out at the same time. That completes my case.
I have any other questions from the board?
Move the hearing to close, the matter be placed on the decision calendar. Mr. Montessori will be notified by mail of the decision once it's ready.
Thank you.
All in favor? Any opposed? Any abstentions?
Next, we have cases 392-23 through 393-23. Merrick, Andrew Harrison. Special exception to maintain accessory structure, shed, higher than permitted and not permitted in side yard. Variance, side yards aggregate, maintains second-story stairs with storage below, attached to dwelling, also known as 3014 Clubhouse Road.
Sure. Lisa Koshia with Permits R Us, 338 Jericho Turnpike, number 396, Syosset, New York, 11791. Good morning, Mr. Chairman and members of the board.
Morning.
I'm here representing Mr. Harrison, who wishes to maintain and legalize a shed and second-story stairs. This property is located in a Residence B zone. The shed is 9.8 feet in height, which is only 0.8 inches higher than the required 9 feet, and it is located in the side yard. The stairs on the deck have an aggregate side yard of 12.10 feet, where the required is 16.2 feet. The deck was originally CO'd in 1992. Sometime after that, the stairs were relocated to the side of the deck. The deck and shed have existed for over 15 years. My client purchased the home during COVID in 2021 and was advised by the prior owner that he had started the process to legalize these issues and hired an architect. They closed on the property, leaving money in escrow, and the architect and the prior owner stopped corresponding with my client. We were then retained to finish the legalization process. Mr. Harrison respectfully requests your approval.
Any questions from the board?
I move that the hearing be closed, the matter be placed on the decision calendar. Ms. Cuccia, you'll be notified by mail of the board's decision once it's ready.
Thank
Second.
you. Have a good
All
day.
in favor? Any opposed? Any abstentions?
Next we have case 394-23, North Belmore. Jose Rivera and Kelly J. LaCourte Velez install pool equipment not permitted in side yard, also known as 122 Ample Avenue.
Good morning, members of the board. My name is Anthony Powell, and I reside at 9 Humphrey Lane, Blue Point, New York, 11715. And I'm here today representing Mr. and Mrs. Rivera, owners of the property at 122 Ample Avenue. They're seeking your approval for a variance according to Article 25, Section 252 of the Town of Hempstead Building Zone Ordinance to place pool equipment in their side yard. This corner lot is uniquely shaped, wider towards the rear and narrower near the front. Considering the special shape and the placement of the existing structures, the side yard turns out to be the most feasible location for the proposed pool equipment. Without the ability to place the pool equipment in the specific location intended, the Rivera family would face considerable restrictions in enhancing their property. This is not a hardship they've brought on themselves, but rather one that results from the inherent constraints of their corner parcel. Within the neighborhood, it's quite common to see homes with pools. The Riveras are committed to ensuring that the proposed pool equipment blends seamlessly with the surrounding area, thereby preserving the existing character of the neighborhood. This variance request is the minimum necessary adjustment required given the unique circumstances of the property. It's a practical solution that would make the proposed pool project possible without causing any disruptions to the overall neighborhood. In conclusion, on behalf of the Rivera family and myself, we truly appreciate your time and consideration of this application. That is our case.
Did your clients have to get a variance for that fence that goes down Elmore Road?
No, there were two sections of fence that were in coordination with the building department and the BZA were removed. There were two sections of fence, one along the western end of the property, stemming from the front foundation down to the end, approximately 26 feet of fence that was removed. That was out of compliance. And then there was a 4-foot PVC fence stemming from the front foundation of the house down to the road edge at Ample Avenue that was also removed.
We have some people in opposition. Step up, please. Yeah.
Good afternoon, everyone, and the chairman. My name is Bill Gatsiaris, and I live in Merrick, and I own the property in Belmore, which it's converted to an LLC, and it's Ample Pines LLC. I have a few things to say about this pool. They want, I'm a little confused. We looked at the paperwork and all the, okay. The paperwork that they were applied with to convey the message to the neighbors around there, they were wrong. The 5 wrong addresses. There were Belmore Avenue. There is no Belmore Avenue there. There is Belmore Road. So all the neighbors they were sent addresses to, they were wrong. So I just want you to check that out, please. And the Ample Pines is not ample, it's backwards. It's Ample, A-M-P-E-L. It's not ample. So that was wrong too, the address. So what they're trying to do, now I'm gonna go to the next thing. The pool heat pump, I'm a little confused. Do they wanna put the pool heat pump on the side or in the back? Because the schematics show that they wanna put the pool heat pump in the side of the house. Is that correct? The request.
The request is to put it in the side yard, but as I look at the diagram, it does to me kind of look like that would be the rear yard where it's shown here for the filter and the heater.
Exactly.
What,
So what is the variance for?
hold on. So reconcile that for us, will you?
Testing, can you? So this was the plan as proposed, and we.
Go ahead.
Sorry. When we received feedback on the application, I guess this was interpreted as being the side yard.
Well, wait, the front yard of the house fronts on Ample, right?
Mm-hmm.
And I presume the portion side of the house that's on Belmar Road is a side yard, the principal side yard, or words to that effect.
Mm-hmm.
So, are you saying that, I mean, if, I'm confused as he is. Is this, first, let's start with this.
Sure.
Is the site plan that we're looking at showing the filter and the heater on the opposite side of the house as what we're calling the front yard, because we know that side, it's the front,
Mhm.
right? Is that where the proposal still is?
Yes, on the north side of the property.
Okay, and, oh, I know what, because they must have defined the rear yard as the, where's the directional? As the west side of the house, so that they could put the pool in the rear yard. So that's why they're defining that as a side. So on a corner lot, the front is what it is, and one side is what it is, but the other two sides, it seems that there's some flexibility as to the characterization. So what clearly happened was the building department just defined the west side of the house as the rear yard, which by operation, by default, makes the side of the yard that abuts, I don't know if you live right next door, but that abuts, do you front on Belmore Road? Where does he?
I do not live there. I'm renting it out. It's Ample Pines LLC. I own the LLC. I don't live there. So maybe when they send the addresses to all the neighbors there, they put the wrong address, nobody got it, and that's one issue. And I want to stick to this thing. I want to stick to the, where the pool equipment is going to be put in. Is going to be put in, if I'm thinking about where the pool equipment is going to be put in, is going to be put in right across my tenants, elderly people. One of them is handicapped, elderly lady is handicapped, and it's going to be put in, this equipment is going to be right across her window, her bedroom window. The pool equipment is going to be put right across the bedroom window. That's one issue.
Hold on one second.
Why can't the equipment be in the rear yard where the pool is? It does seem to be a much better location. There's a garage back there, so it would buffer the sound from the applicant's residence.
In the northwest corner of the parcel we're talking about?
East, I was actually thinking the southwest, maybe, somewhere, you know, because, for example, if it were up against the applicant's garage in the back, it would buffer it from the applicant, who's getting the benefits, so the one we're at least probably concerned about, but it would also move it significantly further away from this gentleman's, the neighbor to the north, and it would be much further away from the other shared property line to the west, because it would be snugged up against the garage.
Mm-hmm.
I mean, that is seemingly, why can't it be there? And it's closer to the pool.
Sure.
So usually that makes it much easier to install and use. It's much more efficient because it has fewer distance for everything to go.
Yeah, for the filter and heater, which will, approximate being 3 feet by 3 feet for each unit, there's only about 4 foot of setback between the one-story garage and the proposed location of the pool.
Right, but if you moved it up against that fence, so it was against the fence and the,
So there is a gate on that fence, a self-latching gate on that fence that runs, I guess you would say, adjacent to the garage along the front foundation of the property.
yeah. Is your house 117 ample?
Across, yes.
On the opposite side of the house from your property, how does that
It's the heaters. I don't know if you're familiar with the heaters, the big units, and they make a weaning.
We are looking at the,
But the
yeah, I
proximity.
mean, there is a house between
They want to put
the
it.
applicant's property and your property and a roadway. And they want to put the filter and the heater on the other side of the house.
On the back of the house?
Yes.
But
the way
that's
it
not what
looks.
the schematic show.
Here, hold it. Show them this. His house is across Ample Avenue.
Drawn it here.
Right? I mean, the mailings. Yeah, that. Okay. His property is here. They want to put that over there.
We don't even have a character, I think that's what
No. Well, what about the issue of,
your line shows. I can read it.
yeah, okay. I mean,
Doesn't matter what we call it.
doesn't get it. Yeah, but what about the defective mailings? Is that? Rob?
Okay,
Could you approach, please?
So,
Location of the proposed pool heater?
yes,
And
yes,
it
I'm
does
clear.
not face your property?
Yes, I'm clear about that, but I have some addition to do. I suspect the only reason why I'm the only one who received the registered
We're
return.
we're going to address that. We're going
Okay.
to adjourn the case.
I suspect nobody got it.
And we'll have
Five
to-
people didn't get the,
Okay. And the applicant is going
I
to have
suspect.
to renotice, he'll have to resend the notices. This case will be put on for July 12th.
We're adjourning this matter
Oh.
to finish this hearing on July 12th. Is it at 9:30? And
9:30.
the applicant is going to resend the notifications to the individuals who are required to receive it. If you're not one of them, since you don't live there, you won't get a further notice, okay?
I
If-
won't.
I don't know, I'm just telling you, mark it on your calendar now, July 12th, 9:30 a.m. We will do this then, okay?
I don't address any other issues.
Not right now.
July 12th. Okay.
Thank you.
Okay, thank you.
Next case, should I recuse myself from this case because of similarity of name?
I was going to say earlier, you just swap the A and the O. Because of that principle you just said.
Edem Shelnans. See, that's the only thing I got out of law school.
Not inclusio veniis, that's exclusio.
That and res judicata. I'm big on res judicata too. Yeah.
Next, we have case 39523, Elmont, Matthew and Francesca Ragona. Variance lot area height, front yard average setback, construct second-story addition with portico which may be conducive to a two-family dwelling, also known as 19 Clinton Street.
I never saw this before. Maybe conducive to a two-family dwelling?
I don't think so. Just turn it on because I think they were not, I haven't on.
Lot area height, front yard average setback, construct
Yep. Good morning. Bernard Rogers, architect, 2150 Wantagh Park Drive, Wantagh, New York, 11793.
Good morning, Matthew Ragona, 19 Clinton Street, Elmont, New York, 11003.
Mr. Chairman, members of the board, Bernard Rogers, architect. I'm representing my clients this morning, Matthew and Francesca Ragona, the owners of 19 Clinton Street, Elmont, New York, 11003, Nassau County Tax Map, Section 33, Block 363, Lot 144, Zone Residence C by the town of Hempstead. Matthew and Francesca are brother and sister, and this is the house that they've grown up in. They're proposing a second-floor addition and a front roof portico. The second-floor addition is being built directly over the existing house. The design of our roof puts us at a height of 30 feet 9 inches from the crown of the road, where 30 feet is the maximum allowable height. We have designed this roof, which is an overage of only 9 inches, to allow for some additional vertical height in the unfinished attic to access storage.
Hold on, I want to, I'm trying to understand why it's here for lot area. There's a house on it, so is that house legally there?
The house is legally there. The plan examiner has cited lot area and the concern that the layout is conducive for a two-family residence.
Right, well then first tell me why, usually we only get lot area either in a two-family that doesn't have 12,000 square feet, or when we're creating a building lot out of carving it off something.
Correct.
Et cetera. So why here, start with why we have lot area before us?
We believe that was a mistake by the plan examiner to cite that, and he cited it was because the layout was conducive for a two-family residence.
Oh, so if it were converted to a two-family in the C zone, then there would be a lot area issue.
Then it would be a lot
but
area
there-
issue.
How many square feet is the lot?
The lot is a 4,000 some odd square foot lot.
So it's
4,400.
insufficient. Okay.
4,400.
How is the house there now legally there? Is it a non-conforming?
No, it's always been a one-family residence, and it's
No, but
always been
how is it
conforming.
legally there? Does it have a CO?
It does have a CO, yes. There's been a chain of title that's been submitted with this to substantiate that. It should be on
So
file.
it's legally there, but we don't know. I'm not seeing if it's legally there, how we are making a determination about lot area.
I would agree with that.
Okay, keep going.
Ms. D'Amato, just for clarification, I did speak with the plans examiner on this matter with the same question. He says because he believes that it could be easily converted into a two-family, he denied it for a lot area for less than 12,000 square feet in the C-zone. We went back and forth on this, but he was adamant that it be denied for lot area for less than 12,000 square feet in a C-zone as a two-family, even though there isn't a second kitchen.
Wow, that is ridiculous. Well, at that point, then it would mean lot area of 12,000 feet.
Would you like me to continue to address our argument for the lot coverage situation not being applicable, or would you like me to move on to one of the other objections?
Lot coverage variance before us. You have only lot area.
Right, the lot area, excuse me.
You can make your case out.
Okay, so just continuing to speak to the lot area. Again, the plan examiner apparently feels that the lot is conducive to a two-family residence. This house is currently and always has been a single-family residence. My clients intend to keep it that way. Francesca will have her bedroom on the first floor of the house. Matthew will have his on the second. They will be sharing the first floor living room, the first floor dining room, the first floor kitchen. Their plan is when one of them gets married, the other will move out. At that time, they will take out a permit to open up the rear of the first floor to make it an expanded family room, and then add 2 partitions on the second floor to put the bedroom spaces up on the second floor of the house.
There's currently one kitchen. Has there ever been 2 kitchens?
No. Nor are we proposing a second kitchen, obviously.
Okay, well, you have something here from someone, I'm not going to read it, it's somewhat lengthy, who defines himself or herself as an interested party. Notably, they mention that there has been constructed a 2-story construction in the back, which can be given to another family to rent. At this time, there is a family who is staying in that space, who also have 2 cars. There's more to it, but
We're not aware of that in
is
any
there
way, shape, or
any
form.
2-story structure there?
I have a garage, that's always been there.
Say
How
it's-
many levels does the garage have?
It's just a one-story garage. It's a one-car garage.
Any attic or anything?
No, no attic at all.
Is there plumbing, heating, electrical in the garage?
Well, nobody's lived in there ever. It's, I keep
No,
my
I
children.
asked you if there's plumbing, heating, and/or
No,
electric.
there's none of that.
There's electrical, I assume, a light?
Yeah, there's lights, but there's no heating, plumbing, there's no water supply, anything like that.
It's only a garage of 12 feet by 20 feet in the rear corner of the lot.
That's the only structure other than the dwelling on.
Correct.
The only structure other than the dwelling on premises.
That's all, there's nothing else.
Yeah, that's the only.
Just a garage, yeah.
All right. So just getting back to the second floor is being built directly over the house. We are proposing a 30-foot 9-inch height from crown of the road. I'd like to note our height proposed is 30 feet from adjoining grade. Our portico is being built over the existing front entry platform. It provides a front setback of 12.7 feet, where 19 feet is required. My clients have no intention of ever enclosing this portico and would, of course, have no issue if that were to be one of the conditions of granting the variance. My clients have spoken to their next-door neighbor, Shamika Lazarus, at 17 Clinton Street. They have shown her our plans and explained why we have to come before the board today to seek relief. She has said she completely understands our proposal, has no issues whatsoever. She has also signed a consent letter that I'd like to submit to the board at this time. Unfortunately, my clients weren't able to speak to their other next-door neighbor about the project. The lady that lived there passed away late last year, and no one has been living in the house since. My clients have spoken to the owners of 15 Clinton Street, 18 Clinton Street, and 20 Clinton Street after they received our certified mailings, and all of them have verbally given their blessings regarding our proposal. I'd like to note our project conforms with all the other aspects of the Residence C zone. We feel that if approved, it will have no adverse effects on neighboring properties or the neighborhood in general. So in conclusion, I'd like to thank you very much for your time and consideration with hearing our request.
Have you been into the cellar of the house?
Yes, I have.
And what's down there?
Right now, it's an open cellar. We're relocating the stairs. We're creating a boiler room, removing the existing boiler room that's there now. We're kind of consolidating the space down.
And these stairs, if I'm looking at this correctly, this is if the portico were constructed.
Mhm.
One would go into the portico, and there would be stairs you can go down, even up.
Correct.
And where are the stairs now?
The stairs now are in the middle of the house.
And why would you use those stairs?
To create more of an open space in the back of the house.
When you say the middle of the house, I see on the first floor where they currently are.
Mhm.
Are the stairs for going, do those go down and up?
Those stairs go up and down, correct.
That's the way, and there's no exterior entrance?
There's no exterior staircase whatsoever.
Well, wait, there's on the back, right? The back goes into the first level.
Correct.
Okay. And how many people live there right now?
Just two. Again, Matthew and Francesca are brother and sister.
Right. Here's what it looks like. This is Oh, okay, I'm looking at the satellite view. I see the two-story structure. I see what I think is the two-story structure referenced in the, the neighbor's remarks. That is, it's that thing attached to the dwelling on the back. What's that? Yeah, that's what they're talking about, that. Yeah, that's what we're talking about. Yeah, but that's what's. I think they're talking about that peak that was added on the back of the house.
The back of the house? The home or the garage?
On the home itself, from the front, there's like, it almost looks like a garage got set on the top of the back of the house. Is it 19 Clinton Street?
Yeah, can you show me? I don't understand what you're talking about.
Here goes show.
Is it the deck, maybe? There's a deck in the backyard.
Just showing that. I think they're referring to that, yes. Because it, from the exterior, would look like, from the front, it looks like a second-story structure attached to the house.
Oh, that's part of the house.
Yeah, that's part of the house that's, yeah, that's part of the house that's coming off, obviously, with our proposal.
What's in that section of the house now?
That's been there since the house, since I've been in the house.
I asked what's in it.
It's an attic bedroom.
Oh,
That's your bedroom.
yeah, it's basically,
That's an attic bedroom. That's a second floor of the Cape bedroom.
that's a hallway, and there's two bedrooms upstairs. So you come up the stairs, and then that's the hall to the bedrooms that are towards the front of the house.
Wait, but that is a bedroom.
No, that's not a bedroom. That thing that you see,
Yeah.
that's not a bedroom. That's the hallway that leads up the stairs to the bedrooms.
It's only a hallway?
You can't put a bedroom there. It's vaulted. There's no.
No, I'm just asking you what's inside that structure.
It's
Is
a
it
hallway.
only a
It's a hallway, yeah.
It looks large for a hallway, that's why I said it's only a hallway.
Yeah, it's.
Okay.
See these other.
That's it.
I have a question. Are there any two families in the neighborhood?
I'm sorry?
Are there any two-family houses in the neighborhood?
Not that I'm aware of. I believe it's a one-family zone.
Thank you.
If you did already, I apologize. I know you said it's a 44,000 square foot lot.
4,400.
4,400, I'm sorry. And the front yard average setback, did you tell us what it is and what you propose?
Yep, so we are proposing an average setback of 12.7 feet, where 19 feet is required to the portico. And again, I'd like to note that my clients have no intentions of ever enclosing the portico and would have no issue if that were one of the one of the conditions for granting the variance.
When, if you know, was the house constructed roughly?
I'm going to say sometime in the 1940s, if not 1930s.
Okay.
That's a neighborhood that goes way back.
And it has a CO.
Correct.
Do you know if it's ever had any relief from this board?
Not to our knowledge whatsoever.
Is it possible it's a legal non-conforming, do you know?
I would assume that would have come up and the plan examiner would have raised that.
So it doesn't have, it's not a legal non-conforming. I thought you got both. How many cars do the applicants, the people who live in the house? How many
Two,
cars?
each one has a car. Again, there's plenty of off-street parking. There's a detached garage and a driveway that runs the whole length of the property.
So, reading a little more so you have a chance to address this from this remarks sent in by a neighbor. They have two big 15-seater vans, which is used for the business, and 5 other personal cars, and 3 motorcycles, and a tow truck.
Ma'am, that is...
Hold on. Take the microphone.
That's my neighbor's house across the street.
That's why I'm reading it, so you can address it.
Yeah, I'm aware of that. Those are my neighbors across the street. There's been several complaints about them. They work out of their house. They have multiple large vans, commercial vehicles parked on the street at all times.
Wait. So you're saying this person who sent in the complaint
Yeah.
sent it in about your house, but in fact, they're referring to another house?
Yes, the man came to my house this morning, and he said, he bought the letter that we had sent out, making them aware of the construction that were proposed. And I said, no, this is my house, not the people next to you. I believe that address is 14 Clinton Street, maybe?
Hold on. No, this
It's
person
not,
put
yeah,
in...
no, closer, it's this one.
Wait, this
Cool.
person who wrote this put his address as 14 Clinton Street.
Okay, and did he put it as 19 Clinton Street that he was referring to, or? Because there's several complaints about that house. It's not my house. It's across the street from me.
Okay, hold on. So let's figure this out, because I want
Yeah,
to know if this is not...
I'm not surprised that there's complaints with that one.
Okay, hold on.
Okay.
So this says the applicant to which they refer as Matthew and Francesca Ramona, which is, well, they say Ramona. And the person who wrote this is Joby George.
Who that is?
Just figure out, so again, you're saying that the allegations in this complaint are allegations that have been made in the past by one or more persons in the neighborhood and pertain to a different house.
Yeah, you might be reading on a different house. My home is 19 Clinton Street. That address is different. We've never
I
had,
understand. I just want to
yeah,
So you know the house to which this refers.
yes.
And now, what did you say about someone coming to your house this morning?
I'm sorry, could you repeat that?
You said that this morning someone came to your house?
Yeah, the neighbor, he lives on the corner. He was telling me, he thought the proposal was for the house next to him, not for my house. And then he saw that it was my address, 19, he came over and he said, is this a complaint for them? I don't know, he was basically asking me if this was for their house. I said, no, I'm doing construction on my house and we had to make the neighbors aware. He wasn't sure what it was, but.
Ms. D'Amato, I believe that the neighbor who's making the complaint is at 14 Clinton Street.
That's
Am I
the
correct?
address that he gave.
Yes. So the issue is with his next-door neighbor at 16 Clinton Street.
Okay, hold on.
I checked on Google Earth, and you can confirm that 16 Clinton Street has 2 vans in the driveway, not 19 Clinton Street, which is
They've
subject to the
also built
application.
a second-story structure to enter the house.
All right, good. So we'll just make the record reflect the complaint and/or remarks from which I read earlier about the two-story structure in the back with people living there, and all the others that I read were all from the same submission by a neighbor, and we've now determined that it does not, that those remarks were directed or to be directed at a house that is not the applicant, so they will not be considered in the board's deliberations on this matter.
Any other questions from the board? Is that your case? Do you have
Yes,
anything
thank you.
else to add? Any other questions from the board?
Everyone who signed in on the case will receive a copy of the board's decision by mail once it is rendered. Thank you. Have a nice day.
Second?
very much.
All
Take
in
care now.
favor?
Aye.
Any opposed? Any abstentions?
Oh.
Next, we have case 39623 Franklin Square, Randy and Joy M. Soho. Variance, lot area occupied, construct addition with platforms and ramps all attached to dwelling, also known as 685 Byron Avenue. Take a seat, state your name and address for the...
It's on. I'm representing Randy Soho and Joy Soho of 685 Byron Avenue, Franklin Square. The property is located on the south side of Byron Avenue, 478.04 feet east of Cox Street in Residence B. We're requesting a variance to construct a one-story addition with platforms and handicap ramp, all attached to the dwelling, which exceed the lot coverage allowed of 27.5%. The lot coverage provided is 31.18%. The work is being proposed because Randy Soho has a genetic neuromuscular disability called SBMA, or Kennedy's disease. The addition will provide for a larger kitchen with a platform and handicap ramp, along with relocating the master bedroom, adding a handicap bathroom, along with alterations to the first floor to allow the hallway to have handicap turning radius. We're respectfully asking the board to grant this variance so Mr. Soho can move more comfortably and safely around his home.
Is this, what is the urgency associated with this? Is this something that your client needs immediately, or?
Yes, he does. He's suffering from Kennedy disease, and
I mean, I
it's...
just didn't know what stage. I don't want to pry into it, except to know if it's at a stage at this time that this is urgent.
Yes.
Have they started to construct it at all?
No, they have not.
All right. Move the hearing be closed, the matter be placed on the decision calendar. Ms. Pangallo, to be notified by mail of the board's decision once it's rendered. As you know, Ms. Pangallo, some of the matters will be decided this afternoon when the board deliberates. Given the urgency of the request here, I'm sure that if you call tomorrow, we will have taken up the matter. Whatever the outcome will be, but call tomorrow so you can find out if the board approved it or not.
Thank you very much. I appreciate it.
You're welcome.
All in favor?
Aye.
Any opposed? Any abstentions?
Finally, we have case 39923 Point Lookout, Gabriella McClear. Variance, lot area occupied, maintain roofed over proposed outdoor kitchen, also known as 100 Freeport Avenue.
How do you maintain a roof over a proposed outdoor kitchen?
Rebecca Manchuk. My office is located at 143 East Park Avenue in Long Beach, New York. I'm here representing my client, the homeowner, Gabriella McAleer. We are requesting a variance for lot area occupied. This is for a proposed outdoor barbecue area of 56 square feet. I know the objection says a roof over the barbecue area. The roof is actually not over the barbecue area. If you look at the rear elevation, It does look like it's over the top of the barbecue, but if you look at the side elevation, you will see the extent of the roof does not go over the top of the barbecue area as well.
What's the lot area occupied you propose?
The proposed is 39.6%, which is 2,615.5 square feet.
How
where-
long has it been there?
It is not constructed yet. The house is a new dwelling.
Wait. It says maintain roof.
Yes, so that is the porch, flat roof.
Yeah, the only thing we're here for is that roof.
That's not,
Maintain.
that was approved a long time ago.
You need lot area occupied to maintain the roof over the proposed outdoor kitchen. That's what we're here for.
Okay, that throws me a little bit because the roof was approved with the house, it's a roof flat deck, which was approved with the house in 2019. So this application that we presented to them was solely for the barbecue and denied from my conversation with the plan examiner.
The barbecue is not before us. The barbecue is not before us. We have an application to maintain a roof over a proposed outdoor kitchen.
There's not even a roof over.
Should we have, maybe, would it make sense to have her go to the department right now?
The examiner was Vinnie Albert. He's very aware of this. I can speak with him if you'd like.
Yeah. Can we do decisions before? Can we do some decisions before? If Mrs. D'Amato will come back. Listen, where did she go?
Oh, yeah, proposed barbecue there. 5, 3, 5. 10, 5, so it doesn't need horizontal, it won't need height, it doesn't need larger. I don't think it needs any larger. She said one of the elevations looks like it's over.
If you look at side elevation, labeled 5, side elevation at barbecue,
Wait, the side elevation or the picture?
not the photos. I have this here if you would like my copy.
Is that little area, that little area is where you're proposing to put?
I'm not sure what you're looking at. Can I approach?
Yeah. Is this right here? That's right. Is that where you want to put barbecue? Correct. So it's here is where they want to put it, which is the same as here. And it's not roofed over. I mean, a little, there's a soffit. Yeah. That hangs over. But. Yeah, that's the soffit. Because it doesn't need any other relief. So I don't even know what barbecue is for.
He's talking about the barbecue. Not talking about the roofed over. We don't either.
If we don't get it, maybe we can just hear it anyway. Should we just hear it and make our own decision?
Right ahead. Make your case.
Pretty much has. Let's do this. So you're proposing lot area occupied of 39.6. You're in a B zone, which allows 27.5%. How similar is this? So in some neighborhoods, this would be a very, very big request. Granted, what you want to put in that space is a roof over space, so it's not as invasive or bulky as would be a structure covering that much land.
Correct.
But in some neighborhoods in this community, that would be a very significant request. Is that the case in Point Lookout, or are numbers such as 39.6 and similar numbers common in the Point Lookout area?
It's very common, actually, to have even greater lot coverage than that, as Point Lookout houses are very, very close together, relatively large houses with small side yards and rear yards. This house is on a double lot, which makes it, have a little bit more space than typical. It's just nice they just were granted for their pool and hot tub, which is being finalized now. So having this barbecue area on the ground floor makes accessibility for them to enjoy their outdoor space and make it usable as the
Why
kid.
didn't they bring that, the barbecue space with the pool and hot tub?
I'm sorry?
Why wasn't it all brought together? I'm just curious.
We want to be able to do the construction without needing any variances prior to, so all of these things that we filed for initially were to get the construction going and have the initial house developed. The barbecue area was something that they decided later on they wanted to add as they decided that the pool and hot tub area was going to be located in that southernmost property.
Okay, so just to get a few numbers on the record, the area where this proposed barbecue is to be, as you already said, 56 square feet.
Correct.
It's not entirely roofed over.
Correct.
As was a little confusing in the vignette on the calendar. But the proposed area that we're talking about is 5 feet, 5.3 feet, I should say. And it looks like the length is 10.5 feet. So even if we were addressing the barbecue kitchen itself, it would not need relief as to height, horizontal maximum, or being larger than the 144 square feet allowable.
Yes, that is correct.
So the board will consider those aspects as it relates to this package proposal.
Thank you.
I guess that would be the only questions that I have.
Is that your case?
Yes, that is the
You've completed your
case.
case. Any other questions from the board?
Mr. Chairman, I move that the hearing be closed, the matter be placed on the decision calendar. One moment. There's another person who signed in on the case.
Yes, she had to leave. That's the homeowner herself, Gabriella.
Okay. Move the hearing be closed, the matter be placed on the decision calendar. Everyone who signed in on the matter will receive a copy of the board's decision by mail once it's rendered.
Second.
Thank you.
Thank you, have a nice day.
All in favor?
Aye.
Any opposed, any abstentions?
Mr. Chairman, we have a second call. If you recall, case number 390 of 23 Franklin Square, Dina D'Agostino. Variance, lot area occupied, construct addition and stoop, both attached to dwelling known as 138 Cruz Street. We tried to reach out to the architect on this matter, who did submit a disclosure, so he would be the representative here. His office has indicated that they are not there for the dates of the 12th through the 16th of June, as it is the 14th. We could not reach out, we could not get in contact, so I'd recommend that the matter be adjourned, and we'll send a notice to appear.
You know, since we adjourn it, but since it's not a maintain, maybe we'll just let them know if they want to keep the case going to let us know. In other words, if it's a maintain, we have to make them come in. This is a proposed construct, so if they want to abandon it, they need to let us know or whatever. All right. And there's no one, and let the record reflect, there's no one here on the matter in opposition or otherwise interested. July 9:30?
Yep. All right. How does PM calendar work? I know we've got, pardon?
Vinny's coming over, let's let him tell us.
All right, so
Might as well resolve that, so we know what to do.
we're going to do decisions now. First
I'll
case,
withdraw my motion to adjourn.
okay, withdrawn. Case 381 of 2023, Inwood. Francia Benavides and Nicole Benavides Carlson. Do I
Okay.
have a motion?
I make,
Any discussion? If not, do I have a motion?
I move case 381 of 23 Inwood at 63 Roger Avenue be approved as requested with the normal two-family conditions.
Same period, second.
Yes, 5 years.
Okay. Second? All in favor?
Aye.
Any opposed, any abstentions? All right, next case, 382 of 23 Atlantic Beach, 139 Bayside Drive LLC. There was a request to make this grant permanent because it is a masonry fence, partially a masonry fence. Do I have any discussion?
I'm not, I think we should consider it, but honestly, I think we should hold it. If it is all masonry, I'm inclined to feel like that's a reasonable request and we could talk about it. It says masonry and wood. The obvious reason we do this is that we don't want someone to replace it where it's not like, you know, if it's probably in a corner, to be honest, or
Okay.
it's got other issues that we want to keep the ability, we want there to be a mechanism in place to monitor that it doesn't.
So we'll hold it,
Agreed.
So,
all
yeah,
right?
if we could hold it and pull the photographs,
Okay.
whatever we have, the diagram.
We're going to digress so that we can listen to the building department representative.
Real quick. So what was on our
How are you?
calendar was a request for a lot area occupied
To maintain a roof over proposed outdoor kitchen.
to maintain a roof over, so it sounded like there was a roof over, and they're proposing a kitchen underneath. The diagram of it is, here's the proposed area. Now let me show you the photographs. So, wait, hold on. Yes, this is the area they propose to put barbecue, which is that area down there. So the barbecue request by these measurements needs no relief itself. She thought she was here for relief over the for the barbecue area. What she understood was the roofed over area here was already approved with the house. She just wanted to come before us for the barbecue. But the
But that's-
barbecue doesn't need relief, I don't believe, except while you're occupied. And it's not really, other than this soffit that hangs over here a little bit. And so we don't know what we're approving. Okay, great. Done.
Thank you. Let's go back to decisions. Next cases,
So much.
383, 384, 385 of 2023, Paul and Tracy Kuntz. Do I have any discussion? And if not, do I have a motion?
Hold on. Yes, Mr. Chairman, as it relates to cases 383 through 385 of 2023, Paul and Tracy Kuntz affecting the property located at 2492 Coral Court in Belmore, I move that that it be granted as requested. Usual shed conditions.
Second,
Second.
all in favor?
Aye.
Any opposed, any abstentions? Next case, 386 of 2023, near Westbury, Eleanor A. Thole. Do I have any discussion, any questions from the board? If not, do I have a motion?
I move case 386 of 2023. Location is 70 Palm Lane, near Westbury, be granted as requested.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed, any abstentions? The next cases, 387 and 388 of 2023, East Meadow, Lewis Koss. Do I have any questions from the board? If not, do I have a motion?
I move case 387 to 388 of 23 East Meadow, Lewis Koss, at 1784 Bard Lane be approved as requested. They
So-
did say that the second floor addition on the bottom would stay open.
Okay,
With that condition, I second the motion.
okay, all in favor?
Aye.
Any opposed, any abstentions? Next case, 389 of 2023, Farron Tomlinson, the wood deck. Do I have any discussion or any other questions from the board?
Mr. Chairman, after hearing all the testimony on it, and considering all the factors cited by the individuals in opposition, to me, this appears to be primarily a method of ingress and egress. It's a 3.4-foot wide. To me, it's like a gangway. Yeah, the applicants want to sit in their chairs and have coffee. The party yard that they have is not being changed, so presumably the parties will be in the same location they've been in the past for their birthdays and other family celebrations. I think this is a very reasonable request. I was not moved by a couple of the factors cited by those in opposition. And I think after weighing the benefit detriment, the alleged self-created hardship, and the character of the neighborhood, I feel like we should grant this request, grant this case as requested.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed, any abstentions? Okay, next case.
And the de minimis nature of the encroachment.
Okay. Next case, 390 of 2023. That case has been adjourned to 7/26 at 9:30 a.m. And the applicant will receive a notice to appear, or we will dismiss the case. Case 391 of 2023, Merrick Jeff Diaz. Do I have any discussion?
Yeah, I do have some discussion. And
Okay.
this is the case where in 2001, the house received a grant from the zoning board to construct the house. At that time, the standard was you could use a ridge or an average from the crown of the road. At the time, this case got a permit to be constructed and was constructed. It met the height requirements of the ordinance at the time. That has changed since, and so the house was approved at its current height, constructed at its current height, and that approval and construction was in accordance with the law at the time of the construction. There have been, as the applicant explained, they have made other small changes over the last 22 years to the house. Enough small changes that did not affect the height, but enough small changes that it was decided that rather than come and ask to maintain these multiple little alterations, they should just file a new case to have the house approved in its current form. And that, of course, ended up creating a height variance request because it was analyzed under today's ordinance and standards. So I just would like, if we're going to grant this, and I would make a motion that we do grant it, I would like a draft grant motion to explain why this height variance, if granted, is granted, so that it's not used later by individuals coming in to claim that it has some precedential value for houses constructed after the ordinance was changed.
Okay. All right. Cases 392 and 393 of 23, Andrew Harrison. Do I have any discussion? If
I
not-
move cases 392 and 393 of 2023, located at 3014 Clubhouse Road, Merrick, be granted as requested.
Do I have a second?
Second.
Shed conditions.
Shed conditions.
Do I have a second?
Second?
All in favor?
Aye.
Aye.
Any opposed, any abstentions? Case 394 of 2023, North Belmore, Horseway and Rivera and Kelia J. Lacourte, Velez. Do I have any discussion?
That's being adjourned.
Okay.
Wasn't that being adjourned?
Yeah,
Yeah, okay.
and I'd like, Mr. Bowe, can we check on that 6-foot fence in that case? Find out.
All right, and
How it got
that
there.
case has been set for July 12th at 9:30 a.m. It's been adjourned, so that the applicant can renotice it, right? Next case, 395 of 2023, Elmont, Matthew and Francesca Ragona, no relation.
I must say, I put inspect on this case. Part of that may have been the inaccurate letter that was sent, but I'm not crazy about allowing them to move the staircase on the interior. I'm not sure, because the movement of the staircase combined with the portico, to me, really does set up an easily not suggesting these individuals will misuse it, but it really does. I see why it was denied for conducive to a two-family dwelling. To me, it looks conducive to a three-family dwelling, frankly. So I would like maybe someone in the neighborhood to take a look at it. There's two people living in it. I don't see how much, there are 3 levels, I don't know. And I'd just like some more input from others about the portico and the move of the stairs. I don't know, Ms. Vogel, if we have a nexus to, I would feel we might have a nexus, given the nature of the denial, the rejection, to say, if we get the portico, we won't allow you to, you gotta agree not to move the stairs. Because it's the combination that lends itself. And given the denial does seem to me to provide a nexus. You see what I'm saying?
No, absolutely. I mean, the only thing that would change if it wasn't considered a two-family would be lot area. It would still be height, front yard average setback, and because those impact the structure of the dwelling being built, I think we can have a nexus as to whether things will be certainly located. I agree.
Yeah, so if we could just check a little bit about the lot area or denial and the how we might make this so it's not so conducive, basically.
So we'll hold that case.
Yes, please.
Case
So you don't have to
396 of
inspect the camera.
2023, Franklin Square, Randy and Joy M. Suhu. Do I have any discussion? If not, do I have a motion?
I move case 396 of 23 Franklin Square, located at 685 Byron Avenue, be approved as requested.
Second.
All in favor?
Aye.
Any opposed, any abstentions? Cases 397 and 398 of 2023, Audrey M. Berger, now known as Audrey Vaney. Do I have any discussion? If not, do I have a motion?
Mr. Chairman, I would move that case 397 and 398 of 2023, as you've described them, Audrey Devaney, I'm sorry, I don't know how to pronounce it, affecting the property located at 838 Leeds Drive, Belmore, North Belmore, be approved as requested, usual mother-daughter conditions.
Second.
Second.
All in favor?
Aye.
Aye.
Any opposed, any abstentions? Okay. Last case on the morning calendar, other than the adjournments, case 399 of 2023, Point Lookout. Now that we believe we know what we're talking about, do I
Yeah.
have any discussion? And if not, do I have a motion?
For the record, the plans examiner clarified for us what is in the calendar, a little bit of clumsy wording, for lack of a better way to put it. This is a request for an outdoor barbecue that needs no relief except for the fact that it increases the lot area occupied over that which is allowable. The roofed over area of this, the portion that's roofed over, was already approved previously as part of the House application. So that being said, Mr. Chairman, I would move that case 399 of 2023 on 100 Feet Road Avenue in Point Lookout be approved as requested.
Second.
Second.
All in favor?
Aye.
Any opposed, any abstention? Cases 307, 308, and 309 have been adjourned to July 26th at 9:30 a.m. What do we have on reserve?
I'll
If
stick with just the hits. 160 of 23 near East Rockway. East Rock Development had provided the board with a draft decision in which a portion of it would be denied for lack of jurisdiction under the doctrine of administrative res judicata, as the case was previously brought before us and denied. And the second portion would be denying the rear yard. It would be the rear yard, lot area occupied, and lot area, which would all be, lot area occupied and rear yard, which would be triggered by the rear deck. Okay, we can hold it, yep, I have another copy in my folder.
PM.
Look at that last edit.
Same with Eisler. Pat, did we get anything on Edwards?
I spoke with Ms. Pangallo. Again, they're waiting for the plans.
Okay, I'll hold, continue to hold on. Cases 249
Yeah,
to
anything on JS?
251, anything?
No, that was what we voted last week.
Oh, okay, yeah, correct, yeah. There's a procedural problem with this because we voted to grant as requested. All they needed was a extension of time because this was previously granted. We called them back in because of the sloppy condition of the property. So we need a revote for an extension of time, not a grant as requested, and a period of, usually even though Mr. Pellegrini does about a year.
Wait, extension of time to do what? This is the one that keeps coming, right?
Yeah.
Yeah, this was an extension of time to, one second, it was to get permits. It was to get permits.
What was the request, what was the basis of the request?
Basis of the request for the extension of time?
Yeah, well, why haven't they got permits?
I can pull up the folder if we want to figure out if actually have.
Joanne, is this the one that you looked at and they had it cleaned up?
Yeah, they had it cleaned up, and I thought that was the end of it.
No, what it was we, when they brought the extension of time, Joanne, Ms. Adams, you knew that it was not well maintained. So in order to grant the extension of time, we wanted to come in, clean the place up a little bit. Oh, no, I remember. This needs time because it needed site plan review. That's it. It needs section 305 site plan review from town board, and they were going through the process with the building department, and that's why it took time. I remember Mr. Minerva did come in and explain that there are a lot of procedural hurdles. That's the reason why it took them time for the
So is that done? Is the site plan review done?
It is not.
No, that's why you need to
He
extend
said,
the
but he
time.
said,
From 17.
but if I recall the testimony, it was imminent that the site plan review was going to be completed and/or the confirmation with the Nassau County Planning Commission.
It was imminent when?
As of when?
Because I would have to
When it
look
was
over the
heard on this
testimony.
date?
We spoke on this date on May 10th.
Okay.
He said
So a
that,
month
yeah.
ago, it seemed that it wasn't before that.
And it was in front of, sorry, it was 149F review from the county. That's what it was. And the county was dragging its feet. They said that, I think they said a month or two it would have been completed, so a year would have been sufficient, if I'm recalling the testimony correctly.
Well, a month has lapsed. I'm not suggesting they should have done that now. So how much time would we think? I mean, well, let's back up. It's all cleaned up now?
Yes.
Okay. I guess we can give them more time than if it's cleaned up. I mean, that's our primary issue. And they have
How
no.
much?
They're complying with all the imposed conditions.
Correct.
And they have no, like, construction materials laying around.
And it was a timely filed extension of time. It's just that we wanted to make sure, we wanted to bring them back in just to clean the place up.
What did they ask for?
Yeah.
They asked for a year, if I recall.
All right.
They asked for a year.
Do I have
Chairman,
a,
I would move that, as it relates to case 249 of 2017 Baldwin JS Sunrise LLC, located at 746 Sunrise Highway in Baldwin, that the board grant them a one-year extension of time to pick up the permits.
have a second?
Second.
All in favor?
Aye.
Any opposed, any abstention?
Concerning the New York land development case, I don't believe we have the supermajority, if the board would like to, because I don't know if we're going to be going against or for the NCPC determination.
Okay.
Well, we can't even vote.
Well, if you vote to deny, you can confirm the NCPC determination. It's only if you vote to overturn it that we need a supermajority.
We'll hold it.
Yes.
Cases 257, 58, and 59, Papio Development Corp.
You want me to do a draft for a two-part subdivision? Yeah, because we don't need a supermajority for the two-part subdivision because it's confirming what the NCPC did, but I'll draft it so it'll make sense.
Next,
Wait, let me just, for the record, as it relates to the Papio Development Corp. This case, I wasn't here when the case came on. I've since reviewed the transcript. I've made a personal inspection of the premises, and for that reason, am in a position to take part in this quorum related to the case.
We didn't get anything
so
on
we are
355, right?
granting, just for the record, we are denying a three-part subdivision, and we're granting a two-part subdivision. So the lots will measure 39 feet each on the frontage.
In width.
Do we need him to submit, I guess before we can grant the change, we need him to submit a layout or plot plan?
Modified plot plan.
We have done something similar in which what I basically did was I approved the first and the third case, denied the middle case, and just said that the portion of the tax lot located on the easterly side, 13 feet of it will be added to the western. I have written
Yeah,
this
but
before.
he may want, he's got to move the placement of the homes.
Yeah.
Okay.
you-
So he's going to have to submit a
because that-
revised
yeah,
plot
it-
plan.
And that has to be looked at by the
The examiner.
department,
Yeah.
make sure he's, and I think we can't put this out the door until we find acceptable the new proposal,
Okay, so I'll tell, this is Mr. O'Brien, correct?
Yep.
to get us the two.
Yeah.
Okay. Anything else on page 3?
We got nothing in
I
road,
haven't
I'm
had a
sorry.
chance to look at.
A mulch okay. I think I advised Patrick, that you want the building department, initially I was going to inspect 362 and 366. I think we should have the building department gain access before we do anything on those cases. I think they're much more adept at,
Okay,
all right?
so can we send the building department out to?
We will, Patrick.
What are, so they're both mother-daughter
Yep.
applications?
Yeah, and there were comments on both about there being multiple people living there, et cetera, et cetera.
Okay, so that's what we want them to look.
Yep.
We'll send the bill.
I need to hold 242 again.
Okay. How about 300, 301, and 302? Cifarelli. That was one, there was a lot of opposition.
Oh, I did.
Oh, is that what
Remember
When I said I
garage?
haven't had a chance to inspect.
Okay, we'll hold it. Case 327, Lido Beach, Rachel
Yeah.
Watts.
I inspected that case. I found it to be consistent with the character of the neighborhood. It was a case that we had already approved, basically the same decks. However, when they decided to elevate the home to bring it in compliance, it led to a recharacterization of this same decks. But I found it to be acceptable, but I'd be interested in hearing what other board members felt, if there's any thoughts on it.
Any other?
I looked at it, I didn't have any problems.
Okay.
Okay, so I
Somebody
would
want to make a motion?
I will,
Good.
327 of 2023 Lido Beach, Rachel Watts, affecting the property at 35 Winchon Street. I move that the board approve the case as requested.
Second?
Second.
All in favor?
Aye.
Any opposed, any abstentions?
Yeah, concerning case 371 of 23 Woodmere, I provided a draft grant, however, we need a supermajority for any sort of consideration of that.
Hold it.
And yeah, that's all I have.
Okay. Nothing on 373, 372, 373?
No, I gotta hold that.
Pardon?
Hold.
Hold it?
This one that you looked at, did you have a problem with this?
Which one? We'll do it after lunch, all right?